Well, welcome to another installment of Season 2 of Real Wealth Podcast, sponsored by Leading Edge Financial Planning. Here on the podcast, we talk about living the best life possible with the time we have left, and also just the entrepreneurial journey, career journey, and life lessons learned along the way. And today we have a special guest, Tim O'Sullivan from Folston Siefken, and he is a very experienced estate planning attorney. That is going to be more the focus today. We talk a lot about lifestyle aspects, but today Tim is going to share with us some of his experience. He talks all the time to other professionals. They have him in for speaking. He teaches at Washburn University, and he's done that for, I think, quite a while.
30 years.
That's quite a while. Very good.
3 decades.
And Tim has a level of knowledge that really, really is special for Wichita. He's one of the very top attorneys in the state, and he's helped write Medicaid law, even at the state level. So I welcome Tim O'Sullivan, and good morning, Tim.
Good morning, Michael.
Yeah, thanks so much. Thanks so much for coming on and giving us some of your time.
Glad to do it.
Yeah. So share a little bit about your background in estate planning.
Well, I went to law school at Washburn Law School, and I got my master's in tax at UMKC, and I thought I was going to do mostly tax. And I started out that in the 80s in tax and primarily, and over a period of about 10, 15 years, I gradually went to estate planning, just stayed in estate planning. But I knew a lot about the tax about estate planning, and the tax side, they started closing all these, they call them loopholes, but planning techniques you could use to minimize taxes. So a lot of your tax work was involved in people that were getting audited and arguing how much they owe. I'd rather be on the planning side. There's a lot more planning you can do in estate planning than you can in tax, usually, just comparatively speaking. So for the last about 30 years, that's about all I've done really is estate planning. So.
And have all those 30 years been with Folston Siefken?
No, I've been with other firms.
Okay.
Hutchinson and Wichita. I started out in Hutchinson.
Okay.
But I could not practice exclusively in estate planning or even tax in Hutchinson. Not enough clients in that area to be able to do that. Which is why most of the major estate planners are in bigger cities.
Gotcha. Yeah, and that makes a lot of sense. Yeah, and with 30 years of experience, I know that you are highly respected at Folston. You pretty much head up the estate planning department, right?
Well, we have estate planning department, myself, Stuart Weaver. We also have 2 younger lawyers, Matt Bish, and now associate came in. And he is, his name is Corey Muma, and he clerked for the U.S. Tax Court for a year. So he's
okay.
And he's going to be primarily in estate planning as well. So we have about 4 lawyers that do mostly estate planning.
And do many of them have exposure in tax law as well? But that's also, you also can't separate it.
Yeah, you can't do estate planning unless you know the tax ramifications of what you're doing.
Right.
So,
yeah, very good.
And especially gift and estate tax, primarily.
Absolutely.
But now things are moving more towards saving income tax and estate planning.
Mm-hmm. Yeah. Yeah, it's interesting how the focus has shifted because the exemptions went so much higher than they used to be.
Yes, right now they're $12,060,000 a year. I'm sorry. So it was $11.7 million last year. Now it's $12,060,000. In about 3 years, unless they change the laws, it's going to go back to half of what it would be at that year. So
yeah,
they're speculating if that happens, it'd be about $6.5 million maybe in 2026.
And for a married couple, that still isn't going to affect most estates.
Very few people file estate tax returns now, and even if they cut it in half, you're going to probably have way less than 1% of estates that file estate tax returns because they're going to be under the exemption.
Yeah.
Right now, it's just a small percentage of 1% that have to file.
Okay.
You're ultra wealthy, basically.
Yeah, and today, so let's transition. I guess first and foremost let's talk about living the best life possible, how that connects to estate planning, maybe what that looks like for you, and some lessons you may have learned over the years.
Well, typically, I think in people, they get older, they tend to be happier. Actually, I think that all the surveys show that, but they were concerned about what happens if I pass away, what's going to happen to my family, who's my property going to go to, what happens if I become disabled, and also what happens if I have to go into long-term care, how do I pay for that? So that's all tied into your finances as well to make sure that they can live a life and not be worried about these from a financial point of view and have it, I call it, tied down. Tell clients you want to tie things down, you don't want to tie them up. You want the flexibility, but make sure you've got these issues covered.
And what does that mean? Can you, I guess, explain it as if I'm a I don't know, a 10-year-old on tying down versus tying up?
Okay. Well, a lot of clients, they focus on avoiding probate.
Okay.
And they want to just avoid probate. And to me, that's probably almost the last priority. I don't have many clients that want their estates to go through probate, but if they're focusing just on probate, they're kind of ignoring all kinds of other issues, such as if they give assets outright to their spouse or to their children, what happens, for example, a spouse, if they remarry, their assets go to a new spouse. What happens if they go into long-term care and they own all the assets, those kinds of issues. So bottom line is the people want to avoid probate, and most do, but it's down the list. People think probate takes years, costs a fortune, neither of which are true. It usually, you could close out an estate typically in 6 months if you get all the work done, unless there's something unusual going on, or you got tax issues to take care of, property you have to sell off. But 6 months you have to wait to close out an estate anyway, because that's the time somebody could come up with a will or another will. And creditors have to have time to file claims. So you don't close it out typically within 6 months. But if you got everything else done, you could probably be ready to close out an estate. So it doesn't take years, and it doesn't cost a fortune. If lawyers charge hourly rates and divide by the size of the estate, it's typically not going to be over 2%, usually less than 1% of the estate. That doesn't mean you have to pay it, but it doesn't take like 10% of the estate like people think. It doesn't. So, but if you want to avoid probate, typically it means setting up a revocable trust, which we could talk about if you want to talk about it. But they want to leave property in trust for their spouse often. So if they remarry, these assets are not going to go into a new spouse. A new spouse is not a beneficiary. If they go into long-term care, they don't have to spend all the assets down to nothing before they qualify for Medicaid, or $2,000, which is the maximum you can have of non-exempt resources and qualify for Medicaid, because the trust can protect against that total spend down by leaving in trust. But at the same time, they want the spouse to have the flexibility to change where the assets maybe go to their children. That's what I'm talking about. Don't tie it up. So they can give that spouse a power of appointment over the trust. I'm getting a legal terminology now, excuse me. To be able to change that by their own will or trust how it's going among their kids. They can't give it to a new spouse, but they can change how it goes among their descendants. So that's the idea of keeping flexibility. And if they decide to leave it in trust and have a different trustee, like a corporate trustee for their spouse, they may want the spouse to be able to change that to another corporate trustee. If the fees are too high, they don't like the people they're dealing with, fine, you could discharge them, but you have to go to another corporate trustee. That's the idea about having flexibility. What are you trying to protect against? Only protect against that. Leave everything else open.
Right. So most of our listeners aren't estate planning attorneys and aren't CPAs and aren't financial planners.
Thank God.
But I guess something I'll call out is estate planning is an area of law practice that, in my opinion, should never be done by a general practicing attorney. And I come across that from time to time where, a business owner winds up using their business attorney or a family attorney, but they don't specialize in estate planning. So the things you were saying, I mean, it makes sense to me, and I also don't talk in those terms on a daily basis. What I think is important to note is that an experienced estate planner is your best value, period.
I think anytime you get into something complicated, and estate planning is complicated, no matter how you try to simplify it, it's complicated. Go to somebody that knows all the nuances. I tell clients, I'm the what-if person. What if this happens? I'll make sure we have that covered.
Yep.
Because if you do something simple, you're probably not covering a lot of things that maybe the client would have wanted covered, but that lawyer either didn't know it or didn't know how to address it in the estate plan. So
yeah. And let's go to the lowest level of what you've seen. There's a lot of online resources available for doing your own estate planning. Do you have any comments about that?
I do. It sounds self-serving to say they ought to go to experienced estate planning attorney, but it's the truth.
Yeah. We
lawyers have fiduciary duty to do what's best for the client, not what's best for us. But if they go to something simple on, which I see right now, that you can get these trusts and wills off the internet, they don't have any nuances. They don't have the sophistication. For example, what do you do about family harmony? How do you protect against families fighting after your death? You can do that with a good estate plan, but you can't probably find those forms on the internet. If you want to leave assets in trust for a child or for a spouse, for the asset protection, we can talk about that. So if they get sued, the creditors can't reach it, or if their spouse can't get a divorce, you have to leave it in trust. Well, how do you draft those? So if you do something simple, you're probably giving everything outright and not considering what happens if these things happen.
Right.
Rather leave it in a trust. I have a quote in that a book that I put together, and it's from H.L. Mencken. He said, "For every complex situation, there's always a simple solution. Unfortunately, it's usually wrong." If you have a complex situation, you don't have a complex solution. You got to have a complex solution.
Yeah.
You got to plan for these what ifs. They got to put them in the document, which makes them a little bit longer, of course, sometimes a lot longer, but it addresses those issues.
Yep. That, yeah, and you do write long trusts, but they're very comprehensive and they provide for a lot of situations that can come up and invariably will come up. We just don't know if it's going to be for that particular client or, surface in that particular way, but it's provided for.
I always come back to what I have. I have tornado insurance and high wind insurance in my house here in Wichita. I know tornadoes have probably moved a little bit east of here now, unless you live in Andover, I guess. But I had an insurance adjuster client. I use that. You want to cover these what ifs. They're probably not going to happen. If they do, you want to have it covered. It's better to have it and not need it than need it and not have it. You've heard that quote before, but it also applies to estate planning. I have a tornado insurance in my house in high wind, and I had an insurance adjuster client that told me my odds of that happening in Wichita, my entire life in a house hitting my house in Wichita, 400 to 1, it won't happen. Why do I have insurance? I'm wasting my premium almost for sure. Because it's worth it to me for the cost for that premium to make sure if it happens, I've got that covered. Earthquakes, that type of thing too.
Yeah.
Well, these things are very unlikely, but if you don't need them, if they're in the document, that's fine. The clients come in, well, I'm not going to have that, but you might in the future. I have no idea. I know what's going to happen. I've got provisions for farmland. I don't own any farmland. You may not own any farmland, but you might buy it in the future. Your spouse, if they're a trustee of the trust, may buy it in the future. If you're leaving assets in trust for the children, they may want to buy assets in farmland in trust, so make sure you've got that covered as well in the document. So they have, and again, you don't want to tie things up. You want to make sure it's open that they can invest in about any type of asset in that trust.
Yeah. Yeah, but they're also not going to walk away if somebody, say, gets in a bad car accident and the other person is hurt in a way that unfortunately may be debilitating for the rest of their life. And because of that level of
exposure,
yeah. That's the word. All of the money that was really left for taking care of the person, providing for them and their family for the rest of their life, doesn't go to providing for a situation that frankly is probably for the most part covered by their auto insurance or hopefully an umbrella policy. But that's a lot of exposure to have. And we actually work with somebody that essentially, even though they had auto insurance, they had good coverage, they pretty much lost the family farm because of a situation similar to that. They just didn't realize that estate planning or a good umbrella policy or both would have been a great protection and also provide that victim what they needed had they just had some good insurance and estate planning done.
I'll give you a couple examples. I had a client come in once, and she had assets left in trust by her dad, and she would get it outright at 50. Well, if you want asset protection for a lifetime, you want to be in trust for a lifetime. But it was going to distribute at 50. She got in a bad car wreck at 42, went over the limits in insurance, and they got a default deficiency judgment for that excess, just waiting for that trust to terminate at 50 so they could get all the assets. So that's when it goes outright. So that it's exposed if it goes outright. I had another client, this happened a few years ago. I did a trust for a lady. She
and let's back up. So explain going outright.
It distributed outright. Trust terminates and goes outright, and then she owns all the property in her own name.
Right.
It's the trust that affords the protection.
Yeah. So why would anyone want to have a trust terminate outright?
Well, a lot of people say, I'm going to leave it in trust for my kids at 30 years of age and give it to them outright.
Okay.
When they're a little more mature.
Uh-huh.
You may want to keep it going beyond that. They just take over their own trust you created for them as trustee and keep the asset protection going for the rest of their lifetime. At that point, they are managing the trust themselves. They're doing their own investments. But that trust, if it's properly drafted, I'll talk about in just a minute, it's not exposed to any third-party claim. Zero.
So they can manage it themselves.
Yes, as trustee.
And it's essential. It's not legally their money. It's there for their benefit.
Yes.
And they have control over it, but it's not exposed.
No. We have a Uniform Trust Code in Kansas, and the provisions to deal with asset protection were last modified in 2014, and I drafted the change to that statute. They're very clear. You can leave in trust if it's for their health, education, maintenance support, which is about everything you could think of they would ever need, cars, houses, that type of thing. They can be their own trustee. You can say they have the discretion to make distributions to themselves and to give flexibility so you don't tie things up. They could also make distributions to their children as well, or any descendant for the same purposes. If they want to give money to a child or grandchild, they can do that out of that trust because they're a beneficiary. Yet you have a spendthrift clause that no creditor can attach it for any reason. And even if it's for that purpose, creditor can't compel a distribution, which is my next example. This lady left in trust for her son for a lifetime. He was his own trustee. These are called generation skipping trusts, which everybody gets the misconception that means it's skipping them and going to grandkids. No, it's skipping that generation's creditors, it's skipping their spouse, and it's also, most of the time, never taxable in their estate, unless it's a real huge amount. So usually these trusts never are taxable in the child's estate, no matter how much it appreciates to. And she did that for her son. Well, he went into a hospital in northeast Kansas, ran up a big medical bill, evidently. And I got a call from the lawyer for the hospital. They got a judgment against him for the deficiency. He either did not have any health insurance or not enough. And he said, I see you drafted this trust for his mother, and it leaves it in him. And I say it's for his health, education, maintenance, support. And that lawyer said, I'm going to go to court and compel a distribution for his health because that's what it's for, to get that money to pay us off. He had not read the statute. I didn't get another call back. He could not attach it. He couldn't compel any distribution. Totally immune from those types of creditors. Car wrecks, anything like that. Divorces, immune from that too. I had a client that deeded a quarter section of land to his son and daughter-in-law out in southern Kansas, either Cali or Sumner County, I can't remember which, but they went through a divorce, and not only did the daughter get half of that because she owned half the property because of the gift, she got the son's half too. The judge gave the whole quarter section to his wife, the daughter-in-law. He had to buy a quarter section back that he'd given. I bet he paid more than fair market value to get it back. So these are kind of things that happen. When you put it outright, it's exposed to all these third-party claims. I tell clients it's the difference between leaving it in a Brinks truck versus an open pickup. Farmers really glam onto that metaphor.
Fair enough.
Yeah.
What would you say to the person who shies away from that level of protection or creating that kind of situation? Because they may say, okay, but that son that you talked about that ran up the big medical bill, I mean, he ran up a big bill. He should have to pay it. What are your comments on that?
I tell clients it's up to you. My job is not to tell you what you should do. I'm telling you what the law will allow for these things. And so if you don't think that, if you think, in fact, I had a client that did that once. Most of my clients leave in trust for that reason. But if it's any significant amount of money, whatever significant means to them, 100,000, 200,000, whatever, so that it's not exposed to third-party claims, and yet they can spend it for their needs however they want. So I was going with this client. He had maybe $2 or $3 million, maybe $2 million. This several years ago. Worth a lot more then than it is now, $2 million, but still a lot of money. And I went through this scenario about leaving it in trust and what it would protect and all that instead of outright. And the client said, I know what you're saying, but here's the way I look at it. He wasn't looking at they should be paying for it. He said, I'm not going to worry about that. That's their problem. Whatever they get is gravy. I'm just going to give it outright. I want it simple. I said, there's nothing wrong with that. That's what your values are. That's what I want to tell you to do. And I'll tell you to do. I said, that's what you should do. I'm not here to tell people what they should do. That's what they can do. Because if we don't tell clients what they can do, we are committing malpractice.
Right.
Just like Medicaid. If they said, well, I don't think we ought to I think people ought to spend their assets down before they qualify for Medicaid. I have other clients that said, well, they lived a high life, these neighbors, and they spent all their money. Now they qualify for Medicaid. I've saved all this money. Why should I be able to protect it? I did. I saved it for that reason. Well, it's their values. But if people think they ought to spend it down, as I put in that book I wrote, that's fine. It's their values ought to be reflected in their estate plan, not mine. I don't have values. I have the legal. Their values apply to what the law can do, and they structure it according to their values, not mine.
Right. And earlier you made a comment about fiduciary duty, where our fiduciary duty is to help clients understand what their options and their decision really is.
Yes.
And to put it in perspective in a way that they can get their mind around it. They can judge for themselves whether or not that's in alignment with what they're seeking to do. And I know that you spend a great deal of time with clients, walking them through, helping them understand, because you do have a thick trust, but at least helping them understand family harmony, why certain things are ultimately possibly more beneficial, say, using a corporate trustee.
Sure.
Using essentially a bank to, well, corporate trustee can be a lot of things, I guess, but really using a third party to administer the trust instead of a family member being set responsible for managing a trust for other family members.
Sure. Before I get into that, I might mention, I think you were getting at, we tell clients the pros and the cons.
Right.
That's our job. They can't make an informed decision unless they know what all the alternatives are that might be appropriate for them, and let them apply their values to those alternatives.
Right.
I look at it pros and cons, benefit versus risk, and their values.
Right. Yeah, I started off in a part of the industry that was really big on teaching us how to sell whole life insurance, essentially to anybody and everybody.
Sure. Everybody needs a policy.
That's right, man. Let me tell you, everybody's got to have one. Whole life. But I joke about that because now I have had a big shift in my perspective of helping people understand, okay, here's your decision. Here's what this does. Here's what that does. Here's where it might fit. And not focused on whole life, but starting with what are their values? What are their objectives? What are their goals? And so we do that from our side. And you do that from your side. But for anybody that comes up on an attorney or a planner that says, hey, you should do this because of X, Y, Z, and that's where they're starting, that should be your first red flag.
Yeah. As I tell my students, never tell clients what they need. If you tell them what they need, that means probably you're substituting your values for theirs. How do you know what they're going to do unless you give them the pros and cons? Then they make a fully informed decision. And often, I believe if somebody tells people what they need, they probably don't know the alternatives or know how to do it. Yeah, so that's right.
And their level of acceptance is much, much lower. Because
I don't want clients to go to another lawyer and say, did Tim O'Sullivan talk to you about this option? And they say, no, he didn't. I want to say, yes, he did, but we didn't want that because of this. They know why they did it.
Right.
I had one client that he said, I need to remember these things. And you did this. I say sophisticated, they say complicated for some reason.
Well,
tomato.
Perspective.
He said, I need to remember these things. And I said, okay. When he called me about a month after I did it, he said, I can't remember what we did. He said, I don't think I want this trust or whatever. I said, I'll tell you what. You come in, I'll sit down with you for free, go over those provisions and see if you want to change a thing. And he did. He didn't want to change a thing because he didn't change his values in a month's time. So he was going to come to the same decisions he had made previously unless his values changed, and they hadn't.
Yeah. Same
values, same document. So I don't like surprises in estate planning because they can be expensive. And so, I don't want things coming up. I can't cover everything, but you can cover most things. And if you do, you put them in the document, they're what ifs. Like I have maybe 8 pages sometimes in more high-dollar estates for tax provisions. I tell clients, I might have put parenthetical under the title, tax provisions. You might want to skip this. I don't do that, of course.
Sure.
But they're not going to understand how to save taxes. I tell them that has nothing to do with who your property is going to, when it's going to them, how it's going to them, or who's managing it. Those are provisions you really need to fully understand. If we have tax provisions that save taxes, there should be more of the money. Like they have people, for example, that if they have farmland, they've got farm payment programs. You want to cover those maybe in the provision of trust if it affects farm payment programs. So they're in there, but all these urban clients will never need that. But if they leave assets in trust for a child, number one, I want to cover it even if they did, but they leave in trust for a child, the child might want to have farmland in theirs.
They also could come into farmland.
Yeah. Sure.
Let's talk a little bit about trustees. Because
that's where you're at, I think, corporate trustees.
I've had a conversation with my own family of, I don't want to be your trustee because I don't want to be the guy with the target on my back.
Yeah, you're alluding to the cartoon that was out, and you've probably seen my T-shirt on that. Far Side.
Okay.
It was a Far Side. There were two deer in the forest.
Okay.
And one deer had a target emblazoned across the rib cage. The other deer says, "Bummer of a birthmark, Hal."
Bummer birthmark.
And I said, that's exactly what we do when you name a child as a trustee of your trust or executor. They're a target. Mm-hmm. And I know from polling audiences in different parts of the country that 40 to 50% of the time when a child is a fiduciary of a parent's estate, there's a family battle of some kind. Mm-hmm. And as you were getting to values, Usually, my clients' number one value is maintaining family harmony. I've had so many clients say, I'd rather give my money to charity than have my kids fight over my estate. But it happens a high percentage of the time when a child serves a fiduciary of a parent's estate because they know nothing about the law about it. They know nothing about taxes. They are managing a trust. So I tell clients it's like hiring a manager of a business that has no experience in the business and has a high risk of giving disagreement with employees.
Yeah.
Is that somebody you want to hire? No. Well, that's the risk you take with a child. And they come back and say something like, well, who do we go to? We'll talk about that in a minute. But I say, well, if you want to have somebody, obviously, it's going to be objective and not a member of the family. Because you can't get rid of sibling rivalry. I don't care what you're thinking. You never know. Parents think rosy pictures about their kids, or I brought them up right. But it's severely tested. And when the last parent dies, the glue that held the family together, parents are both gone, and now they have to distribute the assets in the estate. And clients will say, well, if we go outside the family, they don't know the family. That's a plus. It's not a minus. They don't, because it's a legal and financial issue. It's not a family issue.
Right.
They say it's a family. No, it's not a family matter. It just happens to involve family assets. So if you go outside the family, knows what they're doing, you're going to get somebody totally impartial in this situation. And I did an article for Marquette Law School about 15 years ago about 18 different things that can be battles after an estate when a child's serving as a fiduciary. I was out in Steamboat Springs. I might have told you about this before, Michael, but I polled an audience of 70 CPAs and lawyers. These are farm families planning. It was for farm. They plan mainly for farmers and ranchers. I asked the audience, what percent of the time do you see significant family disharmony when a child is serving as a fiduciary of a parent's estate and there's more than one adult child when a child's serving as a fiduciary? I said 0 to 25% of the time. 4 hands out of 70 thought it was that low. I said 25 to 50%. I couldn't count them. It was about 30, it looked like. I said over half. There are a few more hands over half than under half, but my guess is 40 to 50%. I don't think it's quite 50%, but it's very high.
Yeah.
So,
well, the incentives are there, especially if there's a weak familial tie between a family member or a family member that has maybe dumped the collective family values and gone off on their own, and then they kind of realize, hey, there's an opportunity here.
Oh yeah.
And they want to get at it, or maybe they've been written out. I mean, there's a lot of incentives that can come on board that aren't there when the parents are involved.
No, and a lot of clients say, I don't have enough to fight over. When you want to say something that you don't, like, oh, please. It doesn't take hardly anything, though, to fight over. Distributing the personal effects. Yeah. See, mom gave that. I gave it to mom, and now that given to another of my siblings. Or how about, why wasn't I picked as an executor trustee? They're jealous about who got picked. It goes on and on about the things. And they expect their siblings to do this for nothing. Even though the law says they're entitled to a fee, I've had those go just perfectly until they ask for a fee. No, this is family. They should do this for nothing. With no appreciation, take time away for their family job, have no experience at it. So if my clients go outside the family, I put in the documents why. We're going outside the family, not because we didn't think a child could not manage the trust effectively, properly. We're going outside the family because family harmony is our number one goal. We didn't want to take any risk by putting a child in there of that happening. And I don't put in the documents a high risk. I know it's a high risk, but I don't say that in the documents.
Yeah.
Secondly, we didn't want a child to have to take away for their family or job or to have to do this.
Right.
And 3, we didn't want to have to choose who that was going to be.
Yeah, it turns a gift into a burden.
Oh, it is. It is. It's not a badge of honor to get that from a parent. It basically is something, a target. Yeah, it's probably, as I alluded to earlier, as a metaphor. That's exactly what you are. And other children don't think they're administering it right. They don't like what they're doing. They're not getting informed enough. It goes on and on.
Or they live with anxiety over doing it the right way.
Oh, yeah.
They might get anxious about what the others would think. Even if there's no negative action from other siblings or family members, but just that they're trying to stay above board is enough of a struggle all by itself.
Mm-hmm. If they go outside the family, we talk about a little bit that's bonded, they're not going to lose a dime. I've seen children steal from a parent's estate. And even if they haven't, there's sometimes other children think, what happens to Dad's watch? What happened to this? And they think their sibling took it, who was a trustee. And the personal effects are close to the number one thing they fight over.
Yeah.
And my partner and I, Stuart Weaver, talk about that a lot, about the personal effects. Who gets the personal effects? We say it's the child that has a truck and a key to the house. We call that the Pickup Doctrine.
Oh, my.
I was down in Pittsburgh, Kansas once and talking to a client about this very
Shouldn't
issue.
laugh. Sorry.
Well, you got to laugh a little bit. Can't take it too seriously, but it is a serious thing.
Yeah.
I was talking to a family, and they said that the week before the funeral in Pittsburgh, that the children were all at the funeral except one of the children that didn't go and went through the house and took stuff out of the house. It was just stuff like that.
That is sad.
It's really sad.
Yeah.
And most people think it'll never happen in their family. I've heard that so many times. Never say never. It's a risk. I don't care how well they get along. And if people say, well, our children get along well, okay, then you have a lot more to lose than if they don't. And if they don't, you probably should never put a child in there. If they don't get along, it's going to be a battle, and it's going to run up fees. And they think they're going to save money. They go outside to a corporate trustee, bank or trust company, and I don't do anything to serve banks or trusts, but as terms of a trustee, they do a good job usually. They're bonded. They're totally impartial. If they're experienced and the lawyer's had a good experience in the past, they're probably going to do a very good job for that family. And sometimes, and a lot of times, I give the clients an option. Here's another option. Okay, but what if they're not doing a good job? Okay, you can let your children be what I call trustee dischargers. Discharger sounds like something out of a car or a tractor or something, but it's somebody who could fire that trustee and go to another corporate trustee if they don't like them. So they have the flexibility to do that. But if you name them as a co-trustee, a child with a corporate trustee, they're going to get blamed for everything the corporate trustee and they agree it on. I mean, you just get ready for that. So usually it's best just to have the corporate trustee be in there, but have somebody could move it to another corporate trustee. They can negotiate the fee. They can move it. They don't have to pay the sticker price. But usually that's going to cost maybe 1% of the estate to do that, to have them do it. People pay 6% when they sell a house, commissions. But somehow that 1% they don't want to pay on their estate. Well, here's my experience. If you go outside the family and know somebody what they're doing, there's a lot less accounting fees and lawyer fees because I don't get calls about getting tax ID numbers or how you do this, how you do that. They know it.
Right.
And in fact, I've kind of tried to calculate in my mind anecdotally, but my experience is even if the trustee hires me to represent them as a corporate trustee in the documents I've drafted, which is kind of a traditional way of doing it, the amount of calls I get with experienced trustee and time involved is maybe 20% of the time if it's a child, particularly if they start fighting and the fees go through the roof. So you may save a little maybe, but I don't think so in the long run to do that. So I think we've gone by that kind of philosophy. And client wants to name a child, that's fine. But if they want to do it, so I hear what you're saying, but I still want a child, fine. I've told them, like I'm sure you tell them about investment, this is a big risk. If they want to take a risk, that's up to them. Same thing here. If they want to take that risk, I'm not here to tell them not to. I said that'll be the right decision for you because I've done my ethical duty as a fiduciary, what the risks are. And if a lawyer tells somebody something that's against their economic interest, you know they're telling the truth.
Well,
I mean, we have no conflict of interest if it's going to hurt us to go outside the family.
Right.
And it will usually. We'll get less fees. But that's good for the client, not good for us. And I don't believe, in my case, I've never served as a trustee or a fiduciary of an estate. I never want to for all these reasons. But also, I'm independent. But if you go to a lawyer, for example, I tell lawyers this when I talk to groups. And lawyers are usually not think about whether they're really a good fit. Typically, their hourly rates are going to be too high to manage an estate. It doesn't take a real sophisticated person to do an estate sale, for example, or distribute the personal property. If you're charging $200 an hour to do that, though, that's over billing, really.
Mm-hmm.
So it's not financially feasible for lawyers. If you do it, you're overbilling probably. And you have to see whether your malpractice insurance covers that.
Mm.
And do you have accountants and bookkeepers on staff? Probably not. Most lawyers are not really good at accounting. I hate accounting. My wife's an accountant. She does my books at home. But I'd rather do the legal work. rather than accounting work. But and you could have a paralegal maybe keep good books, but I will tell you, corporate trustees keep great records. Any third-party fiduciary like that. So that's often the choice. But I give them several names they could pick from, corporate trustees. They can interview them. But if you go to interview somebody as a corporate trustee, that person you're interviewing may not even be there at the time you die. So you're going mainly on the reputation of that facility. And generally, if that changes, then have your trust reviewed every couple of years and see if it still fits. You could always change the trustee anytime you want after your death. Not after your death you can change it, but you can change what will happen after your death while you're living. So evaluate, just like your trust, review that every couple of years to make sure, or will, to make sure that it still fulfills all your goals and meets the current laws. That's usually about a 10 or 15-minute conversation. Short.
Sure.
Nothing's really changed, really. Is that your goals? Yes. And you're fine.
Yeah.
But that gives them comfort.
Good. Let's talk about what size of an estate makes sense to put together, whether it's a trust or a dual trust type of estate plan. When does it make sense to go from a will to a trust? Because a will is a pretty simple procedure. You can do a simple will, especially online, and I know it's maybe not the best. It doesn't allow for a lot of control. But if you don't really have any assets to give, maybe that's a fine approach.
Well, it's going to go through probate. It's not the worst thing in the world, of course. It's a matter of public record, what you've got, who your assets are going to, and a lot of people are very concerned about that. The level of concern tends to be in, proportional to the size of the community they come from.
Yeah.
Maybe, let's go to like Emporia versus Wichita. They'd be more concerned about privacy in Emporia probably than they would be in Wichita.
Sure.
Unless they're a high-profile person in Wichita. But if they're doing something like disinheriting a child, they may not want it to be, or maybe they want it to be a public record. We don't like this kid.
Ouch.
I'm joking.
Yeah.
I'm joking.
But
that's hard. But I mean, that'd be a kind of bad motive if they did that. But often they don't want that to be a matter of public record.
Sure.
What I look at is that trusts are not that difficult to draft, especially in the world of computers. They take very little more time than it takes to draft a will. You hear people, it takes a lot more time. Well, people are charging a lot more for drafting a trust than a will. Then, to me, it's not built upon the time it takes. It's built upon the better trust. I'll just charge you more money. But if you have goals like, say, protecting assets, like Medicaid, we'll talk about it. What if I go into long-term care? Or you don't want your spouse they remarry, give to new assets. You're going to have to leave it in a trust to do those things. And you can leave it in a trust under a will, but your will will have to say it goes in a trust, where you're going to have to go to probate, have an executor appointed, go through all the procedures, which is not that expensive, but it's a little bothersome to clients to have to do that. Matter of public record, and then have the judge declare that these assets now belong to that trust. Last will and testament, a testamentary trust is a trust created under a will. But to get that property into the trust for a spouse or for a child, or they're going to have to go through probate to do that. So a lot of people want to avoid that by doing a revocable trust. So it kind of boils down to, if you're going to leave assets in trust for anyone, for any of these reasons we're talking about, then it's easier just to have it in trust in the first place. And just stay in trust for the spouse or stay in trust for the kids. Free and clear of probate, the trustee has full authority, those assets, to put them in the trust for the kids or for a spouse. And oftentimes that trustee, if husband and wife, will usually be the spouse. Maybe not with a second marriage, kids on both sides. That's a whole other game. And that's the most complicated plan of all. It's usually way too simplified by lawyers, which is why you have all these fights from children on both sides when one spouse dies. But most all of that can be avoided by proper planning, but it's not simple. You've got to cover these issues. And that usually means going outside the family. That trustee, you don't put one. I've had situations where they want basically a child on both sides to be the trustee. I tell groups, it's like tying the tail of two cats together. And that's what you're going to have.
Have you ever done that?
Uh-huh. You haven't?
Oh, I haven't tried it.
I haven't either, but I've heard about it.
Okay.
Yeah, it's going to be a battle.
Okay.
So you can guarantee it when you do that. So it's usually something that shouldn't be done. But you can avoid all these problems by proper planning, but you're not going to get that off the internet. You have to think about it and how we're going to be the trustees. What if this happens? Simple forms are not nuanced. This is what's going to happen. We don't care what the situation is. You got a child that's disabled the time they die, and they're on SSI, which I've had that many times, and you got a will that gives it outright. You're going to disqualify them for Medicaid. It's all going to have to be spent down to $2,000 before they're going to qualify for SSI or Medicaid again.
Right. So the gist of all that I'm hearing is it's not so much about the size of the estate, but the size of the impact, which may not be obvious.
No. And for husband and wives, they want to be sure probably that if they become disabled, that they don't have to spend a last dime on their assets in a long-term care facility and leaving nothing for their spouse, particularly. Maybe they won't leave something for the kids, but more likely than not, the main objective is that both of them are provided for the rest of their life. If one goes to long-term care and they're spending $8,000, $10,000 a month, like Alzheimer's, it can drain the finances very quickly.
And that actually is something I was just going to bring up was not just Alzheimer's or dementia, but early onset. Because
early onset Alzheimer's?
Yeah.
Yeah, there's a lot of that.
Yeah, you're talking about...
I shouldn't say a lot, but it happens.
Oh, it does happen.
Yeah.
And actually, I'll just say somebody that I'm aware of has it right now, and they're in their early 60s, and that could drain that could disrupt the entire financial plan because their body is still in well enough health that they could live for quite a while.
Oh,
but if they need memory care for 10 years, 15 years, holy cow, that totally disrupts their financial plan.
And it can be physical. I had a client who was in long-term care 16 years.
Right.
And a lot of that was physical. The last 2 or 3 years, she didn't know where she even was, or the family, which gets into living wills and making sure that doesn't happen, which is part of the plan. But I know we're not getting into that right now, but it's usually we're talking about finances. And if you have a plan, even for a modest estate like $200,000 or $300,000, and you haven't particularly comes to even more acute the lesser the assets are, you plan for these.
Yeah.
You don't have no money to cover that. But you have the ability to move assets back and forth between spouses for Medicaid reasons, that one spouse doesn't leave assets outright to the surviving spouse. Because 35% of the time, even if they qualify for Medicaid, they spent down enough for one spouse to qualify for Medicaid, the well spouse will predecease the spouse who's in long-term care, 35% of the time. When I first heard that statistic, I said, that's way too high. Then you get to thinking, wait a minute, the one that's in long-term care may live a long time in that condition, and it's a lot of anxiety that the well spouse has been through, can shorten their life expectancy, and if they die and all these assets come over to the spouse in long-term care, they'll be disqualified until they spend all those assets down, which leaves nothing, and they'll be on Medicaid after that. Rather leave it in a trust, which you limit what has to be spent down for that surviving spouse. But you have to have that in place.
Right.
So when I have clients even in their 40s and 50s, I think, well, it's something you got to think about. You may not want to plan for it, but you may want to have it set up to plan for that. So you have the two trusts set up. You want to avoid probate, all that. People think, I should have said this earlier, not just drafting the documents. They say you have to get the assets titled in there to avoid probate. Well, you do. They think that's costly. It's not that costly. Maybe it's about 20% of the total fee to get it funded. But you're going to have to go through the assets anyway if someone dies. It's a lot better to have it in the trust now where you've got a calculation what you own. The next trustee comes on, they know exactly what you own, where it is. Mm-hmm. It's a good step to take, but it's not that expensive. There's a little bit more expense in setting up trusts, but not a lot.
Yeah.
They're not any more complicated, really, because all these tax planning you do or leave in trust has to be in the will if you're going to do that too. So,
speaking of Medicaid, let's say it's been paying for the benefit of a spouse for some period of time. Can they, once that spouse passes away or the second spouse passes away, can Medicaid come back in and put a claim against their estate?
They can. They can't do it when the first spouse dies, the surviving spouse. So when the first spouse dies, even if they were long-term care and the assets come over to the surviving spouse, they don't have a claim then. They can put a lien on real estate. But when that surviving spouse dies, they can have a claim against that estate. Mm-hmm. But there's ways to protect that. Most of that is by leaving it in trust. You can protect for sure, but you can definitely minimize what has to be spent down and minimize the prospect of estate recovery by proper planning. But again, you can't get it off the form. It's off the internet to do that.
Right.
Anybody in their 50s, if they don't have long-term care insurance that's really going to cover them for a good period of time, you got to consider, make sure what happens for Medicaid if they run out of assets. Limit what they have to spend down before they qualify for Medicaid.
Yeah. Another cool Medicaid ninja move that you did for one of our clients recently was one of those Medicaid qualified annuities.
Yes.
Yeah. Could you explain what that does in simple terms?
You're asking the impossible of a lawyer, you know that. But typically, what you do is before the infirm spouse can qualify for Medicaid, they have to get down to $2,000.
Okay.
Well, best thing is then transfer those assets to the well spouse. Assume it's a first marriage again, not kids on both sides. They would want the other spouse to get it. But you have to have it in your power of attorney that if they're disabled, somebody can transfer those assets over to the well spouse. Otherwise, they're stuck with those assets. And they'll have to spend those assets down to $2,000 before they'll qualify for Medicaid. But if you can transfer it to the well spouse, then the well spouse has to get down to certain assets before they qualify for Medicaid. That amount is currently maxes out about $130,000 of non-exempt assets. House is exempt, cars exempt, an IRA of a well spouse exempt, but all the rest of these assets have to get down to $130,000 usually, or less. And so, depending on how much is in there, call it division of assets. I won't get into that because that's really complicated too. So it takes me about 2 class periods of my class at Washburn to my students. And judging by the exams, I'm not sure how they got it either.
Great. Let's put a pin in that one.
Okay. So they get over to the well spouse to limit what they have to spend down in assets. So they do that. And let's assume that they have to get down to $130,000. They've got $200,000 cash, mutual funds, whatever it is. They've got a house that's exempt, a car, but everything else they have to get down to $130,000. That's what they have to. That's the division of assets in a nutshell. What they can do is they can buy when you do that, a Medicaid compliant annuity. The income of the well spouse has no effect on the infirm spouse's qualification for Medicaid. It's the assets only. So if you buy a Medicaid compliant annuity, you transfer in like cash. They had $200,000 of cash. I'll make this really simple. They have to get down to $130,000. They could buy a $70,000 annuity. I usually buy more than that to make sure you get under $130,000. Just dollar-wise, $70,000 Medicaid compliant annuity that pays that well spouse back the whole amount over a period of time. I try to make that as short as possible. You can even do these for 4 months even. Get the money back in 4 months. You're not going to make much interest in 4 months, but that's not the idea. Because if you buy this Medicaid compliant annuity, that turns it into income as far as the state's concerned, Medicaid. And now you are down to $130,000 of other assets. You could apply for Medicaid immediately.
Mm-hmm.
And you should qualify for Medicaid even though you're going to get that $70,000 back. Now, people say there should be a law against it. There's a law for it. 2005, Congress passed a law that you could do this. Now, people say there shouldn't be, but I'm not going to tell people what the law should be. I'm not a legislator.
The law is
I'm a
what
lawyer.
it is.
Exactly. If they don't like it, change the law.
Right.
But you can do that. You can do other things, too. I could talk about loans to kids with interest and all that. They usually don't want to do that route because they're not sure they'll get paid back. Medicaid compliant annuity, they'll get paid back for sure.
Right.
And they don't want their kids to get involved anyway. There's so much you can do. People think you got to spend it down. So here's a state that maybe had $200,000 of cash, house, car, and everything else. The infirm spouse is now qualified for Medicaid with buying a Medicaid compliant annuity, which pays off in 4 months. The reason you want 4 months is because the first beneficiary of that annuity, if the well spouse dies, has to be the state to pay back what they paid for the infirm spouse for Medicaid. Well, the chances of that spouse dying in 4 months close to zero, so most every time they're going to get that money back, and there is no Medicaid claim. And then if they die, they're going to leave assets in trust for the surviving spouse as opposed to outright to disqualify him from Medicaid. And that trust is not subject to Medicaid claim by the state because the surviving spouse doesn't own that. So you can minimize the spend down for moderate estates, and believe me, saving $70,000 for anybody in that limited assets is worth it to them to be a little more complicated.
Right.
So
absolutely.
But they need to understand what they're doing and why. So they're already set up for that if they've got the documents in place, 2 separate trusts, powers of attorney to cover this if that ever happens.
Okay, before we go on to, because I don't want to squander the time we have with you and the wealth of knowledge you can bring to the table. There's one more scenario I want to ask about, and then we can move on to just sharing a little bit about personal life lessons you've learned over your career. Mm-hmm. Maybe a point of profound growth that you want to share about that. But the last estate planning oriented question I want to ask is it a good idea for someone to deed a property to one of their kids to get it out of their estate?
Well, I told you about the farmer that deeded a quarter section of land and lost it to a spouse in a divorce. Usually no. But it's not my idea to tell them what's a good idea.
Okay.
If you deed it to the child, here's what could happen.
Okay, let's go there. What could happen?
Divorces, lawsuits, It's fully protected every claim that child might have against them the rest of their life if they own the asset. If they left it in trust for them, which is typically if that farmer had asked me before he did that, that's what I said. Why don't you leave in trust, let your son and daughter-in-law, but your son's the trustee, and if they ever go through a divorce, she would have no claim. She's not a beneficiary. Well, he didn't do that. Anything outright, it's fully exposed to every claim they might have.
Yeah. Yeah, and despite what we'd like to think idealistically of any couple, especially family, especially of kids, that their marriage is going to make it. The odds are still it's a high risk. It's still a large risk.
I tell people if you had 3 kids, usually the odds of 50-50 divorce, right? One's going to go through a divorce. If you figure out what the odds that none of them will go through a divorce, it's 1/2 times 1/2 times 1/2. It's 1 out of 8 times none of them will go through a divorce.
Right.
7 out of 8 times there'll be a divorce.
Mm-hmm. Yeah.
And a good chance of going to long-term care, well, that's pretty high too. If you live
Really
long
high.
enough to get there, really high. So by leaving trust, you protect them against that too. So that's why trusts are such a good tool. There are some countries that don't acknowledge legally a trust, like Germany, France. Trusts come from common law countries like England. That's how we got it. We still have a trust. But you don't have that option of leaving trust in England or Germany or anybody else. It has to go outright. So we're very fortunate we can get asset protection by doing that. By leaving in trust, you can even keep it out of their estate. You can also save income taxes too, not by you, because if you have a revocable trust, it's still taxable back to you, the income.
Mm-hmm.
If you die and leave in trust, let's say for a spouse and the kids, the spouse being the trustee, that spouse can take the income of that trust, distribute it down to their kids, and they pay it their bracket, not the spouse. If you can save even a 10% bracket on distributions over a period of time, that could be a large amount of income tax saved. So a lot of talked about getting it mostly out of tax, but the tax aspects of trusts and how they're taxed is very important to know when you're doing estate planning, so you can save income taxes as well.
Yeah. Well, that has been just about 50 minutes of a wealth of estate planning knowledge.
Wow.
See how
Didn't
fast
realize
it goes?
You told me to go fast.
Yeah.
Yeah.
It goes really fast. So, what? Okay, so you've been around the block for a minute,
Yep.
and much longer than myself. What advice would you give, or maybe just share a personal lesson learned, whether it's through adversity, a defining moment. Do you have a story you can share on a point of growth in your life?
I've been pretty lucky with my life. Got 2 good kids, married, good marriages both live in Texas. My daughters both went to Baylor. I heard if you send them a daughter down to Texas, they're not coming back. I said, okay. So they went down there, and they didn't come back. They married good Texas gentlemen. So I've been very lucky with good kids, good spouse. We've had good marriage, and she's worked as a banker. She's been a trust officer. She teaches accounting at WSU now. Good careers we've enjoyed. The main thing is to treat your family well, treat your clients well, be honest for your life all the way through. Clients will respect that. Your family will respect that.
Yeah. Yeah. Did that value grow out of anything in particular, or where did you get that value?
Parents.
Awesome.
Yep.
What a blessing.
My dad was an FBI agent.
That'll do it.
Yeah, I had to comply with that.
I didn't know that.
Yeah,
That's
yeah,
awesome.
he was. And my mom actually worked for the FBI in the clerical area, and that's where they met in Jersey City, New Jersey.
That'll keep you honest.
He was in New Jersey, Cincinnati, Salt Lake City, all the different. They moved him around a lot, the FBI agents. So, and he was very honest and well respected, and so did my grandfather in Hutchinson. So I learned a lot from them.
Wow. So
I had
cool.
to.
That's so awesome.
Yeah.
Yeah, one of my favorite shows. Now I've watched it till I'm sick of it, but one of my favorite shows was watching Lie to Me, and the character in there is Dr. Cal Lightman, but it's actually based on I it escapes me at the moment. uh, but anyways, so Dr. Paul Ekman did all kinds of research, neurolinguistics and microexpressions,
Uh-huh.
and how they're connected to our emotions. So there's all kinds of things that are intrinsically connected to the muscles in our face and how we express emotion, because it's hardwired and it's universal.
Mm-hmm.
But he was hired by the FBI and other departments of government to train them on reading neurolinguistics at a microexpression level and understanding how emotions connect. So it's so interesting that your dad and your mom were both in the FBI, potentially trained with some of that. And I don't know if that came around during their time or after, but that was a huge part of their training. And but man, I love that show because it's actually set up. It's designed to teach you. We're getting a little off topic, but designed to teach how to understand what somebody's feeling and begin to be able to see, hey, does that even jive with what they're saying?
Mm-hmm. Well, he was. Most agents at that time didn't stay in the FBI a long time. They used it and they went into business. That's what my dad did. He was in there about 6 years.
Okay.
He was actually in there during World War II. And back then they didn't have the CIA. I think the OSS, I think it was called. And FBI agents were being sent to South America against the Nazis who were infiltrating. So he was one of those who went down there during World War II.
Oh, this is where, then that's way ahead of Dr. Pollack.
Yeah, he was went down as a Portuguese magazine writer.
Interesting.
But he had to learn Portuguese, went down there, Brazil, I think probably maybe Argentina. But they're mainly Portuguese-speaking countries only. That's what he learned to speak. So, but it was a little bit dangerous, but got through it, got back, and then he went into business with my grandfather in Hutchinson, steel company in Hutchinson, for a number of years after that. And that's how he got to Kansas, because he grew up here in Kansas.
Okay.
And then he sold the company in the 60s. Then he went to head up a trust department at a bank.
Okay.
And did that for a number of years, then retired. So he's passed away now, but he was a pretty fulfilled life.
Wow.
So
yeah, that's what a neat career.
Back then, they only hired attorneys and CPAs in the FBI. That was it. J. Edgar Hoover, just attorneys and CPAs. Why, I don't know, but he never practiced. He went to law school, Marquette Law School, and never practiced. He went straight in the FBI after that, and for 5 years till after World War II, then he retired from the FBI. But anyway, that was his story.
Yeah, so World War II era, when it was just getting, or I guess even maybe just pre-FBI.
Pre-CIA.
Pre-CIA.
Exactly,
okay.
yeah. But, he had a life lessons he taught me, and what, and we learned it, our family, and fortunate to have him as a dad, and my mom as well, so. Anyway.
Yeah, and I would hope that we all can pass on legacies like that. That if nothing else, we teach our kids to be honest, to have integrity, to do the right thing, and that's what a legacy that they left.
Yeah, sooner or later you got to turn them loose, right?
That's right.
And you always have that feeling, especially, and when your child goes off to college, that's an emotional impact, especially a daughter for a dad. They're out of your control, and you can think what things I should have done maybe, or should have done when you raised them, goes through your head. I think about every dad goes through that when a child goes away to college. Yeah, that's wired too, probably for most dads.
Yeah, it's on that one, I guess my perspective, and I struggle with this because it's so hardwired that we're put here to provide for them, to protect them, raise them upright. But I guess from my faith perspective, they were God's before they were mine, and I'm called to raise them right and model and teach and mentor with integrity, and help them to formulate perspective that is going to serve them well, and to adopt that while they're with me. But at the end of the day, I have so little control over what happens to them
That's when you realize they're going to go off to school.
Yeah.
Exactly.
Yeah, but that's a notable point for, hey, this is, they're launching.
Oh, yeah.
Yeah. So cool.
But anyway.
Anyways.
It is what it is. So.
Well, Tim, I am grateful for the values your parents instilled in you and how that's led to a long career in tax and estate planning, and you've served so many families and helped them preserve family harmony despite a bunch of kind of crazy incentives that come into the picture once estates are being settled and there's a lot of money kind of moving around.
Mm-hmm.
And little control over who has a say in what's happening.
Yeah, they all tend to have a say once the parent dies. All the kids,
Right.
And I tell people the risk of family disharmony is not so much the size of the estate, although that certainly is a factor. It's the number of kids and the number of in-laws.
Mm-hmm.
That is the driving factor, what your risk is.
Absolutely.
But overall, I think it's at least 40%.
Yeah.
Sad. If you have more than one child.
Right, and if you have a lot of kids, it's even higher.
Oh, yeah.
Yeah.
We might mention one thing about telling the kids about the estate plan.
Yeah.
Talk about that shortly.
Okay.
When I did that article for Marquette Law School, I started looking up any articles. I couldn't find any article for lawyers on family harmony, preserving it, not one. I didn't have it in law school. I didn't have any seminars when I got to law school, and I think so. I had kind of get this on your own. I'm still preaching it, trying to get out there, and still doing a lot of seminars on this. And lawyers don't disagree with me very much, and I don't really care again what the client does, but I certainly want to tell them what the risks are and what their options are. But when I could find, so I looked at websites for lawyers, what their advice was. I didn't find any articles. And the vast majority advice was, tell your kids about the estate plan. It clears the air and avoids surprises. Not in my experience. It does. In fact, they think the kids ought to know about the estate plan. And what that does is open up all kinds of issues probably you don't want to go into. Like, Mom or Dad, why are you going outside the estate plan? We'll get along. Or, gee, if I'm naming this child, why aren't you naming me? And the pressure, or I've had this one. Mom and Dad, if I die first, I want my spouse, give my share to my spouse. You know how many parents want to do that? Close to zero. They're worried about giving to the in-law. It's not going to get down to grandkids. They usually want to go to grandkids if the child dies.
Right.
So you get that issue. And I've even had this one. Mom or Dad, can I have some of my inheritance now? My inheritance?
Mm-hmm.
They have no right to money, but kind of entitlement, they think, to do that. And so I don't think a whole lot can come good about naming the kids or telling the kids, naming the kids and also tell them about the estate plan.
So you would generally advise against, and I've heard this being done, of doing like a family style meeting of like, hey, let's share with you what the general estate plan is. So you generally advise against it.
Well, I tell them what the risk is. It's high in my experience. I started mediating family disputes about 15 years ago. And one of them I got was a doctor who died up in northeast Kansas. He had a video of the meeting and the kids and everything else that they went through. Oh, everything was just fine until he died. And then as I say, the fecal matter hit the fan.
Well,
I don't want to get real gross about it, crass, but that's what it.
What about the situation? Let's say there's a family held. Let's say there's a father. Let's say just father son in partnership with a family business.
That's an exception.
Okay,
I have that in my book. If you have a family business, you better have a business succession plan. You just don't dump it on when you die and hope it works out. You get a chance to try it while you're living. Maybe this child's a good manager. Maybe they're not. Maybe they don't get along with the other kids. I mean, you don't see how it works out. Sure, that needs to be tried. So, Stuart Weaver, my partner, have talked about this a lot, but that's an exception, we think. You need to have that probably talk. Mm-hmm. Farms, who it's going to, how it's going to work out.
Yeah, because there's a client I work with. So the father and one of the 5 children were working the family farm.
Uh-huh.
And the father left it equally to all 5 kids. So the one's livelihood that was dependent on the farm just got divided by 5. And so it created a lot of family heartburn. And hey, these things come up, but it's preventable.
Yeah, the way you normally we want to approach that is you typically do not want a passive family member. You got one running the business and the other is just passive, like they have non-voting stock, like in an LLC. They get a share of they just get the income off of it.
Mm-hmm.
That hardly ever works out. They're unhappy. They want the money. They don't want the land, or their spouse pressures them to get it. So they make life miserable for the person who's managing the farm or the business. Same thing.
Or they sell it off out from under them.
Yeah, but if you put an LLC or something like that, they can't do it. If you have land that's all tenants in common, no joint tenancy, even joint tenancy, don't put joint tenancy with children where it goes one dies, it goes to the other one. They each own an interest they can give to their family however they want. It only takes one child to have a partition suit and probably force a sale of the entire land, that parcel. You can't divide it up, so the judge will force a sale and they split the cash.
There is another family scenario that happened with a property in the area, and the kids I think were mostly spread out, but yeah, it was it turned them, they turned so nasty on each other.
Oh, it's ugly. But there's ways, yes, as you were talking about, to avoid that.
Yeah.
Maybe buy insurance for that to equalize the shares.
Right.
And so that passive person gets cash instead of land.
Mm-hmm. Yep. Create a funding source.
Oh, yeah.
Yeah.
And if you set up a limited liability company, maybe you want to try that while you're living and see how it works out. But yeah, it's usually best not to have a passive child owning and other children are controlling.
Right. Do the best up front to get the interest parties aligned with harmony. And, and there's a lot of tools for that, especially when someone were to talk to you.
You'd have those talks, but somebody who doesn't have a farm or closely held business, they're going to leave on to their kids, and they don't want it sold. They want to, you probably need to have that talk. But if you don't have a closely held business or farm, it's hard for me to think what scenarios really they need to know about. A lot of them are going to plan their spending based upon what they think they're getting from the parents. But if you do that, I'm getting this share, it's not money, so I'm just going to spend high because I'm going to inherit this money.
Right.
That's probably
I don't need to save because my retirement will be inherited.
That's probably not the child you want as head of the healthcare power of attorney.
Yeah.
I'm joking about that, but
yes,
yes and no, exactly.
You joke, but the incentives are screwed up.
Exactly, they are. So, but I've had clients that said, okay, they went ahead and told their kids anyway. And a couple of them said, well, it went fine. My response is, then you didn't need to tell them.
Right.
It's when you tell them there's problems that you'll find out till you tell them. But it is, and kids will even after you got it set up, maybe you got a third-party trustee, the kids will even pressure the parent to tell them about that, and they try to pressure them to name themselves. I have them come back and I just want to name my child now because they've been pressured by that.
Yeah, why don't you trust me?
Oh, yeah. Not a matter of trust. Things are going to happen in any family.
Or even a spouse that, they may feel entitled to, like what you're talking about, if the parents want to leave it to their kids in their lineage, but maybe a spouse wants to somehow get involved in what's being left specifically, and then a divorce happens down the line. But there's all kinds of risk to that. But I think there's a lot of wisdom, unless there's an exception, to keep it to just keep it to the parent's decision, keep it private until it kicks in gear.
But you put that in your documents. As I said, if you're going outside the family, you put why. Family harmony, I'm doing this. That's never caused a problem after death when you tell them that.
Right.
What can they do? The parents, they can't argue with the parent. The parent had good motives, family. They can say we would have gotten along, but I wish they would have named us, but there's nothing they can do about it, and it doesn't create any rift between children if they've gone outside the family. Because if you name a child, they're going to probably think that child pressured the parents or talked to the parent about naming them. And you hit all stuff after death.
Right. And also for the parents to write a letter explaining their thinking, just from them on top, like possibly in addition to the documents of, hey, here's why we did what we did in case there's any question about it.
Mm-hmm.
Just for your information. Yeah.
If you're giving more property to one child than another, that's something you probably want to put in the document.
Mm-hmm.
Like I've had many of those situations where they've given a lot of money to one child during their lifetime, maybe overindulged them. We put in the document, I'm leaving less money because of this. We gave this one child during their lifetime. We felt it was only fair that we equalize it with other children at our death. Put that in the document.
Yeah.
You don't want to put it in there if you're being unequal because you don't like a child. We don't like this child. You would never say anything like that. But something like why there's a good reason why you're doing that. You put that in the trust document.
And psychologically, it just helps because they're not just getting money; they're going through a grieving process.
Oh yeah.
They're
very vulnerable at that time.
Absolutely.
Oh yeah.
Yeah. So to give them mental reasons to square up what they're experiencing is really helpful, because it's not even just what they're experiencing. That's going to impact how they interact with other family members, because that could cause a rift if they don't have a reason that specifically says, here's why it seems, or here's why it's not necessarily the exact same amount for everybody, or here's why we did what we did. But it gives them something to attach it to. This was done on purpose because of this reason. And there's no reason to resent your siblings.
No. In fact, if that's the case, that decision was made on my own. No child influenced me in my decision-making in this document. Just put that right off. Now, they may not believe it, but it's going to be in the document. And usually that's the case. They're not going to be influenced. They're doing it on their own.
Absolutely. Well, Tim, thank you so much.
Well, I've enjoyed it. Thanks for having me.
I can't wait for the bill I'm going to get for this. I'm kidding.
I'll put NC, no charge. Okay.
Oh, okay. Thank you. Oh, that's very gracious.
Yes.
But yeah, thank you so much for volunteering time and putting some education out there for people that may not specialize in estate planning and may not have talked to a highly experienced veteran in the world of tax and estate planning.
Thank you so much. Enjoyed it.
Thank you so much. Well, that'll wrap up this installment of Real Wealth Podcast, sponsored by Leading Edge Financial Planning. Here at Leading Edge Financial Planning, we help our clients make wise financial decisions. Thanks for joining.